Good evening, everyone. I'm delighted to welcome you all to today's class on compelling parties to arbitrate under a valid arbitration clause, rules and exceptions. I'm honored to stand here before you as we delve into the intricacies of arbitration, exploring rules that govern the process and exceptions that may arise in compelling parties to arbitrate under a valid arbitration clause. Today, we embark on a journey to understand the rules that guide the enforcement of these clauses and the exceptions that may challenge their compelling force. To this end, we have the honor of hosting Mr. Param Bhamra, an alternative dispute resolution expert who is the founding partner of Mediate Guru, co founder of Licit Elite, and founder of Diplotix. He has published over 9 books and has had an illustrious career in international mediation and arbitration. He's a graduate of the Guru Gobind Singh Indraprastha University, following which he pursued his LLM from Vivekananda Institute of Professional Studies. It is a pleasure to have you here with us, sir, and look forward to an interesting and enlightening session tonight. Thank you.
Thank you so much, Tashish, for the wonderful introduction. And thank you, LawSikho, for having me here. I'd like to apologize to all the audience currently tuned in due to some, I don't know, problem with the camera. I won't be able to, turn my camera on. But I assure you that I am here and I hope everyone can see the slides. I'll take that as a yes. So the topic we have here today is that compelling parties to arbitrate under a valid arbitration clause. Now we will cover in upcoming slides as to why do we need to compel parties to arbitrate and what are the intricacies of a successful arbitration clause, what are the rules, what are the exceptions. So please bear with me. Thank you. So in this lecture, we'll cover arbitration in India, we'll cover principles of a valid arbitration agreement. Then, as I mentioned earlier, we'll discuss, why to compel parties to arbitrate. Then again, what are the exceptions to enforcing arbitration agreements? Then some recent developments, judicial trends, and moving on to conclusion. So, first of all, arbitration in India. In India, arbitration is covered majorly by Arbitration and Conciliation Act, which is loosely based on UN Citral model law. But uh, what we need to understand majorly is that what is the aim of arbitration? Not arbitration in general, but ADR. Why is ADR important? Well, the main aim is to you know facilitate quick and speedy resolution, to minimize the supervisory role of court, and get everything done quick and fast. We'll get on it in the next slide why. So again, now I'm not assuming the level of ADR or arbitration. You guys know if you are professional, intermediate, beginner. So I'll just quickly start with what is arbitration. I'll try to explain that with a hypothetical example. Hypothetical example being, you know, for example, Rahul is a person living in an home in Delhi. So as a mean of extra income, Rahul thought of a plan that let's install a geo tower or any other company tower for that matter, Airtel, Vodafone, whatever, that let's get them to install a tower on their rooftop. All right, sounds fantastic. So he reached out to some company, they agree, and they sign a contract. Now let's assume a dispute arose, you know, of any nature. Maybe the cost is too much, maybe the weight of tower is meaning on the structure of the building, anything. Now, if Rahul and the telecom company didn't had an arbitration agreement or an ADR clause, in case of any dispute, both of the parties will go to the court, fight it out. It will take a year, 2 year, 3 year, 4 year, 5 year. No one knows. So what will happen is that tower will stay blocked. The company will have no other option. There will be bad area, bad network in that area. You can assume the state of the people living in. And as for Rahul, he won't be getting any money for that period. So it's a loss-loss situation for both. Now let's assume that at the time of signing of the contract, they both decide to put an arbitration agreement in the contract so that if any dispute arose of any nature, they will just simply go for arbitration. They both will mutually decide one arbitrator who will decide the case for them. Now that can be resolved in a month, in 2 months, or 3 months. Maybe it will take a year, but it'll be certainly you know quicker as compared to our traditional court system. So which one would be better? That's I think it's obvious, but please let me know what do you think would be the better. Moving on. So as we talked about the arbitration agreement, why it's important, it's quick, it resolves easily. So what can be classified as a valid arbitration agreement, or you know what what all should be in a document that we can call that a valid arbitration agreement. First of all, no brainer, it should be in written. It's of the utmost important that arbitration agreement should be in written form. Secondly, there should be an intention to arbitrate. Like, you shouldn't just put arbitration if the both parties don't even want to arbitrate. Arbitration should be put in if the both party had the valid intent to arbitrate in a dispute. Moving on, the agreement should be definite and clear. Like, what type of dispute to be referred in arbitration. I'll give an example. I handled a case based in the Gulf. That was the company was of gaming industry. It was a gaming company. So what they do is sometimes it's a recent trend which is going on in today's time. That is, they'll put a monetary limit that all the cases having dispute value less than $100,000 are subject to arbitration, and all the dispute having more monetary value than $100,000 will go into mediation. Now, why is that the case? Again, cost. Arbitration is very expensive. We'll get on to that in a moment. So, the arbitration agreement should be definite and clear as to what is the type of dispute the parties can sign an arbitration agreement over. It helps in upholding the validity of arbitration agreement in case of any dispute between the parties in court. Moving on, there should be a valid contractual relationship as to agreement must be and part of a valid contract. Valid contract, as we all know, mutual consent, competency, lawful consideration, etc., etc. Then the most important part is that separability. Earlier in the above point, I mentioned that there should be a valid contractual relation, that arbitration agreement should be part of a valid contract. But even if the contract is not valid or it turns out voidable later on, the arbitration agreement is separate from the whole of contract as to if there comes a question in a contract that whether the contract is valid or not, even then the arbitration clause in the said contract will be valid. Moving on, subject matter as taught above, that subject matter of the dispute should be arbitrable. For example, dispute shouldn't be criminal, matrimonial, divorce disputes, insolvency proceedings, etc., etc. Mutual consent, we already discussed above. Then parties should be specific, that in an arbitration agreement, it should be specific as to who the party is, and if the dispute arose would be in which parties, party A or party B. That's very important that the agreement should specify the parties. Moving on, compelling parties to arbitrate. So there are some times when one party who has already signed the arbitration agreement, refuses to participate in an arbitration proceedings. But why? Why would the party do that? They signed a contract in the starting that if in any case the dispute arose, they will go for arbitration. So why does generally parties refuse to arbitrate? There are numerous reasons. First, it can be, a malified intention on one party, that they know, they are wrong, and they can leverage court delay to figure out, their strategy in the meantime. Like, if I know I'm wrong at some point and I go to court, I go for arbitration, I'll, they'll, the decision will come quickly against me because I know I'm wrong. So if I do know I'm wrong, I go to court, I go to arbitration, I'll get an unfavorable decision in, let's say, a year in arbitration. But if I know I'm wrong and I go to court, I'll get that unfavorable decision in 3 to 4 to 5 years. So I have a lot of time to figure out what to do. Other than that, sometimes the parties just want to annoy the other party or be dominant. Further, it's less likely, but sometimes when the parties don't get the uh, president, president of tribunal, arbitral tribunal, of not their liking, then the parties again can go to court just for the sake of it. So, you know what to do if a party is not willing to go to arbitration and they are already in, what do we say, when they already have signed their agreement, the other party can go to court under Section 8 of the Act and, request the court to send the other party back into arbitration. And even court, if court finds out that there is a valid and binding arbitration agreement, then the court will not hear the matter and the court will straight away send the matter to arbitration proceedings. The court, it's not necessary that the court, you know, if only court find out in a preliminary uh, part of the, hearing, that if they found out early on, then they'll send the parties to arbitrate. But if even if the court has reserved the judgment in the case, if all the witnesses, testimonies, everything is done for, even at the last stage, if the court finds out that there is an valid and binding arbitration agreement, they will send the parties to arbitrate. Moving on, as we already discussed this part, circumstances under which parties can be compelled to arbitrate. There should be a valid and legally binding arbitration agreement. Legally binding, as in we mentioned, there should be mutual consent, no undue influence, no coercion, all the basic of contracts. Then the dispute within the agreement scope. So what happens is sometimes the subject matter or the agreement scope is challenged, and that can go into summary determination in an arbitration proceedings. But sometimes what happens is, let me explain you with an example. Suppose Rahul had a farm and Rahul wanted to lease out that farm to Mohan. So they signed a contract, your typical lease contract. And in the contract, they mentioned that if in case of any dispute arose, which is of, let's say, immovable property, any dispute of immovable property will be handled with arbitration. All right. So both the parties go ahead, get on with their life. Rahul went Rahul went into the farm. He noticed that there is a crop, you know, there's a crop growing on the field. And after some time, Mohan, which had leased the property from Rahul, Mohan also noticed the crop, and Mohan goes on. He sawed, he cut off the crops and he sold it in the market and put the profit in his pocket. Now Rahul objected to this. He mentioned that, it was my land, it was my crop from before, I should get the profit out of it, not you. But Mohan said that, since I had the lease, it's mine. Now the dispute arose. Mohan filed for an arbitration proceedings to resolve the dispute. But, Rahul went into court and said that the dispute is not fallen within the agreement scope, as the crops are part of the crops are not immovable property. So both the person have different opinion of whether the crops would fall in immovable property or whether it will fall in movable property. So this interpretation is something which causes summary determination proceedings to go on. We'll get on it at later part. But as we were talking about, parties can be compelled to arbitrate if the dispute falls within the scope of the arbitration agreement. If court finds out that you know that the crops are indeed immovable property, then the matter will go into arbitration proceedings. If the court finds out that the crops are movable property, then the case will go on in court. So that's why it is um, it is said that dispute can be arbitrated only if they fall within the agreement scope and not outside of it. Moving on, request for judicial intervention. As we said, if one party is not willing to go to arbitration, even if the agreement provided for it, the other party can move to court in Section 8 and request court to direct the other party to go into arbitration. Then it's somewhat important. No significant prejudice to legal rights. Okay, so let me try to explain this to you with an example. Court can only compel the party or the parties to go to arbitration if court is of the opinion that there will be no prejudice to legal rights. Now, what is this? For example, suppose I signed on a contract with a firm ABC, and we decided that, if in any case of dispute related to my services happen, we will go to arbitration in, let's say, Europe or Geneva. So we both signed the contract. Amazing. A year went by, 2 year went by, everything is going perfectly fine, everything is awesome. But some tragedy happened and I got broke. I am poor. I have no financial means basically to support a trip to Geneva. Then, as my luck would have it, there arose a dispute between me and the firm ABC. So, you know, arbitration proceedings will be initiated, but I don't have the funds to go to Geneva. So, if I don't go to Geneva, the arbitration tribunal will grant ex parte order in favor of the other party, and I will lose my legal rights under it. So, can court compel me, to arbitrate under that agreement, which will hamper my legal rights? No. So, courts can compel parties to arbitrate only if court is of the opinion that no significant prejudice will happen to my legal rights. Further, the agreement should not be void ab initio. That will hinder if the agreement is void ab initio or voidable. Then there's a chance court might not compel other party to arbitrate. All right, moving on. So, what are the exceptions to this rule? First exception is as we taught in earlier, that is invalidity of the arbitration agreement. That again can be if the arbitration agreement has been signed with coercion, mutual consent, fraud, undue influence. Further, non-arbitrable subject matter, that is again your divorce, fraud. Now earlier, fraud is subject to scrutiny whether fraud can be arbitrable or not, such as there are some cases, it's on case to case basis, like if there's a generic fraud in some corporate company, this person has fraudulently earned some bit of money, it can go into arbitration. But then again, if there's a significant fraud which actually affected people's life, caused stress, then it can be treated as criminal. There was a bit of gray area in the matter in previous. We'll get to it. Then vagueness or indefiniteness. That is that if or when you sign an arbitration agreement, it should not be vague or indefinite. If the arbitration agreement is vague, then court might not enforce that arbitration agreement. Let's take an example like if an traditional arbitration agreement, we put that we'll see if we want to arbitrate in future or not. If that's in the clause, then that would amount to vague, right? You have to be very specific, very word oriented. You can't afford to be vague in your arbitration agreement. Further, violation of public policy. As we mentioned in the last slide, that legal rights should not be violated if your arbitration agreement is somehow violating the public policy, then the court can refuse to enforce your arbitration agreement, such as access to justice from the last one. So it is of the utmost importance that your arbitration agreement don't violate the public policy. Then there is incapacity of parties. The parties who have signed the contract should not be minor, should not be of unsound mind. Your traditional contract act stuff. Moving on to relevant case laws, we have the case of N. Radhakrishnan versus Metro Engineers, in which the from before whether fraud disputes can be arbitrable or not. In this case, the court held that allegation of fraud are not arbitrable. Before there was this confusion as to whether allegations can be made or decisions can be given, that generally what parties used to do is whenever in case of any dispute, in order to get out of arbitration, they just used to put an allegation of fraud, that this party XYZ has committed the fraud, so we are going to court and not into arbitration. So the whole dispute matter falls outside the jurisdiction of arbitral tribunal. What happens nowadays is that if there's a allegation of fraud, the court only hears the allegation of fraud, and all the other charges, all the other issues carry on in an arbitral tribunal. Uh, so then we come on to Booz Allen case, in which court ruled that certain disputes, such as right in rem disputes, are not arbitrable. Again, as we mentioned, public policy disputes, access to justice disputes, they are not arbitrable. Moving on to Atri Masala case, it provided that uh, arbitration clauses become inoperable if the underlying contract is void. For example, if a minor has signed a contract and in that contract there is an arbitration agreement, then since it's void ab initio, the whole of contract will go inoperable, including arbitration clause. Remember this in the doctrine of severability. Uh, if it's a voidable case, then the arbitration agreement will be operable. But if the whole of contract is void ab initio, then the arbitration clause will again become inoperable. So these two go hand with hand. So moving on, recent developments and judicial trends, as we have noticed, is that court are strict in order to uh, enforce arbitration agreements. If court even get a sniff that there is an arbitration agreement, court will not listen to the parties anymore. Court will strictly go on and refer the parties to arbitration. Now, why does the courts do that? Because again, as we know, there are lots and lots of pending cases in a judiciary, millions of cases, and the only way courts can get a bit of relief is by promoting ADR as much as possible, and court will have to enforce arbitration agreements if they want to promote ADR, and what do we say, in order to have a bit of breathing room to focus on actual important cases rather than somewhat commercial cases which can be easily resolved by private parties such as in arbitration. Further, there is a narrow interpretation of exceptions which are there for non-enforcement of arbitral agreements. as courts are narrowing the scope of exceptions and trying to limit it as much as possible, meanwhile promoting arbitration to resolve most the dispute. Courts are providing clarity on non-arbitrable issues, providing a set of guidelines such as the cases of fraud, insolvency, matrimonial. So things are becoming more and more clear by the day. Then courts are being seen not to intervene in arbitration after the case in 2019 Balco case, Chanjan National Highway case. We can see the courts are trying hard to stay out of the way for arbitration and letting the real development begin for the, what do we say, because the promotion of arbitration. All right, we'll get to an in conclusion part. Then courts are recognizing emergency arbitration awards, which is a very essential part, and recognizing, you know, emergency awards goes a long way in people trusting arbitration more and more. If a person have an emergency award, generally if an emergency erupts, people go to fast track courts because there used to be no provision for speedy disposal earlier. But since emergency arbitration took some trend, it's getting support from courts as well. And then speedy disposal of application. Courts are disposing of the application as soon as possible in order to let ADR took a whole band of more cases and take the burden out of judiciary. Moving on to conclusion, what I'd like to say is that Indian legal system is showing a strong commitment to arbitration. If we see, we currently are now living in a golden age of arbitration. As many of you might have noticed or remembered that we Bar Council of India has recently allowed for the entry of foreign law firms in India. So why did we do that? Why did we allow for and foreign firm entries into India? I think the main reason is that sorry. Yeah, I think the main reason is that we allowed the entry of foreign firms is to promote arbitration. Because if you see the objective of why the people, uh, as to the objective that the reason the area of practice foreign law firms can practice in is either arbitration or in order to consult their clients for international law. So we can see that our our Bar Council of India is also trying to promote arbitration. And one of the reason which I personally think is important for arbitration in India is that it is providing for an economic boost to our country. Before 2019, before the 2015 2019 amendments in the country, what used to happen is parties will go foreign, for example, a foreign company will come to India, they will invest some XYZ money, they tie up with some Indian company, then there will come a dispute. They'll they'll preferably have a seat in New York or London or Singapore, as they wish, and then their arbitration proceedings will happen. After arbitration proceeding, they will go on. The award will come. If the award is not in favor of Indian party, they will just come to India and they will set aside the award under section 34. So that became a trend. Owing to that trend, foreign firms, foreign companies was somewhat hesitant to come work in India or invest in India. But ever since that 2019 amendment and the Basel adjustments in which the court have separated both the, what do we say, have separated part 1 from part 2 of the arbitration act. I'll assume you know part 1 and part 2 of the act. So uh, as courts have separated part 1 and part 2 of the act, it provides for more freedom to foreign firms and foreign companies to conform to you know come to India and invest in our economy. And we know what good our what good the foreign investment will do. Our dream of $5 trillion economy, soon to be economic superpower. So what I think is arbitration is putting up a major milestone in that, and one day or sooner it is very good for our economy, and one day arbitration will be a norm and court system will be an alternative dispute resolution. And that uh, I close this by, if you still don't know what arbitration is, I'll tell you what I explained to everyone. Arbitration is nothing but a private form of court. It's the same system. The decision will be binding. There will be expert testimonies. There will be witnesses. Everything is the same. The only difference is it's the private form of court. It's not the government or state-sponsored justice system. And over the decades, we have seen there is a shift from state-sponsored institutions to a private-sponsored institutions. Like earlier, we used to go to government hospitals. Now we go to private hospitals. Before, the kids used to go to government schools. Now they go to private schools. So that change is inevitable, and it has been there in the West already, but it is taking up traction in India, and I am very glad to see that, and hope you guys got to learn something from the lecture. Thank you so much. If there's any questions, please do let me know.
Thank you so much, sir. It was an extremely interesting and enlightening session. If you don't mind, we can open the floor for questions now.
Yeah, please.
Uh, so, if anybody has any questions, you can please put them up in the comments. If anybody has any questions, just put them up in the comments. Uh, so I don't think there are any questions for now. So maybe we
No
can
worries.
just end. Before we end, I would just really like to thank you for taking your time out and contributing to this project. Uh, we all learned something extremely valuable tonight. Thank you so much.
No worries, no worries. Thank you so much for having. And if anyone comes up with a question later on, you know how to reach me. So again, thank you so much for having me. It was quite an opportunity. Thank you so much.
Thank you, sir.